you should get to know if you have your CC&Rs, you've got your bylaws, you've got the rules, but then you have local, state, and federal laws.
Right.
And we've seen it multiple times, California being an example of a law change in California, for instance, for ADUs. They've made it a lot easier for drought-tolerant plants and for solar, but those are in complete conflict with the CC&Rs.
Yes.
And a board may say, our CC&Rs say you can't do X, Y, and Z, but there is a hierarchy of the law. If those CC&Rs haven't been updated to support that law, they might not be valid.
I'm Luke Carlson, and for almost 2 decades, my law firm, L.S. Carlson Law, has been at the forefront of defending homeowners against overreaching HOAs. We're not just leading the charge, we've created the go-to playbook on how to fight back effectively. Join us as we delve into the world of HOA disputes, sharing insights from our extensive experience and landmark victories. Throughout this podcast, we'll bring you in-depth interviews, demystify complex legal principles, and provide practical tips to safeguard your rights. While the information provided shouldn't be taken as legal advice, our aim is to empower you with the knowledge, strategies, and real-life success stories needed to navigate and overcome the challenges posed by overreaching HOAs. Hi, Luke Carlson of Bad HOA. Welcome back to the podcast. I have our co-host, Marty.
Hello there.
Hi.
Good to see you.
Good to see you. And yet another exciting episode, in my humble opinion.
Yeah, this is one where I think it stitches multiple episodes together into something super concise. We've been talking about this for a while, that we need something where homeowners could reference something quickly to start as a starting point for a dispute or dispute resolution.
Yeah, I mean, there's different ways to frame what we've produced here, but I guess going to homeowner empowerment, we're looking at tools.
Mm-hmm.
What tools can we give the homeowner to empower them against bad HOAs? That's sort of the premise, right?
Yeah.
And this is really another tool that we're rolling out in a series of tools that we'll be, I guess, rolling out at the end of this year. It's already, December.
Yeah.
And as we go into 2026. So let's jump right into it.
Well, let's I want to give some context.
Oh, context is good. Yes. I was so excited.
So I think this spring, the podcast will be 2 years old.
That's right. Yeah.
If that, which is which is mind-boggling.
It's great. Time flies.
Yeah. And we've have a lot of amazing content. And I feel like we've walked through people multiple steps along the way on what to do with certain types of disputes. But I feel like we needed to consolidate that into something that someone can just look at and just go A, B, C, D all the way down.
Well, there's a common thread and approach that we've identified over and over.
Yeah.
And if you look at all the shows, they're consistent with this approach, this mindset, and this tool that we've developed is really that approach in a very simple formula.
Yep.
And I would say you could call it a formula, you could call it an algorithm, you could it's a strategy guide, tactical guide, but it's very straightforward, very simple to use. And at the end of the day, it's going to put you at an advantage going up against a bad HOA.
Yeah. So let's drum roll, unveil. We call it the strike method, and strike is an acronym, right?
Yep.
So we're going to go through the acronym, and again, the whole point is it's a homeowner starting point to solve an HOA dispute without an attorney.
Yeah.
This is your guide. Use the strike method, and you'll see how it kind of unwinds. So it's kind of step 1 all the way through. If you follow it, hopefully this is a good starting point. We're hoping that a lot of homeowners will solve their disputes with this method.
Yeah, a lot of what we're doing is we're hoping that you don't have to use a lawyer. You sort of use these tools and you get a good result against your HOA.
Yeah.
And this is a good starting point to say, okay, how am I going to approach this dispute? And it doesn't matter what the dispute is. It might be water intrusion, it might be harassment, it might be selective enforcement. All of the things that you might be dealing with, you look at this method, this is the way to approach the dispute, irrespective of actually what the dispute is.
Yeah.
So it's a nice way to sort of guide you through the process. And of course, listen, if everything goes south and it turns into a dumpster fire and nothing works, you could always go to a lawyer.
Yeah.
But before that, this is the way to think about it. So again, we called it the strike method. We wanted it to be sort of proactive, offensive, not reactive.
Yep.
And that was important to us when we developed this. So let's jump right into it now.
Let's go S.
Okay. So S is stay calm.
Yeah.
And we've discussed this so many times.
But for those who haven't watched the episodes on this, I think it's super important. So let's go through it. Let's dissect it a little bit.
Yeah. So as consulting attorneys, as lawyers in this field, what we see so consistently, and rightfully so, is homeowners with very upset, angry emails to their board.
Yeah.
And on the one hand, I understand it entirely. They're upset. Their kingdom is under attack, right? Or their biggest asset is depreciating. And so you see the visceral, you see that anger in the emails. But at the end of the day, that's not going to help you at all.
Yep.
In fact, you're giving ammunition to a bad HOA.
Yeah.
So the stay calm is really to ensure that you have a clinical approach to the dispute.
Yeah.
You take that emotion out of it.
Yeah.
And, one of the things that we do, with, technology being where it is today with AI, let's say you write a really visceral, venom-laced email, you could always put it onto an AI, platform and say, please take the emotion out of it.
Yeah.
Distill it down to its fundamentals.
Yep. Because
at the end of the day, that's the paper trail, and you want your paper trail to be reasonable.
Yeah.
You want to set that stage where everything that you've done, every interaction with the board has been even keeled.
Because let's fast forward that a little bit.
Yes.
Because if it gets to the point where you're in mediation or another lawyer on their side's involved, arbitration, or even it goes to litigation, you want, to your point that you've made multiple times, you want the paper trail to show that you were even keeled and you were the reasonable one throughout the entire process.
Right, because that email that you send at 3 a.m,
yep,
it's screaming at the board. And again, I get the sentiment, I get where you're coming from. That's going to be front and center. When it goes to mediation, let's say, or the mediator's the first thing that he or she reads,
yep,
or it's in litigation, which could either be arbitration or state court.
Yep.
That is going to be used against you. So stay calm. It's always going to behoove you.
Yeah. And then with that, we say keep messages crisp, factual, and concise. So no reason to over-explain anything. Again, just assume. I think this is a good thing to remember. Just assume that everything will be in front of a judge or mediator
or neutral. Yeah.
So just assume it's going to be in front of somebody. Yep. Every single thing that you send, just assume multiple eyes are going to be on it and they will be scrutinized. I think that's a really good tactic to have in the back of your head, or at least strategy to have in the back of your head.
Yeah. So S, stay calm. Moving on to the next one. This is so important. T, track everything.
Yes.
And this, I love it, especially when a client or potential client comes to us and everything's in writing, again, like clinical writing, not angry writing and over the top emotional writing, but everything has been recorded. Everything is in a file. And, because at the end of the day, if it's not in writing, it didn't happen.
I love that saying so much. I think we've said it multiple times on the show, and we actually, we put a note here as well. If it's not in writing, it didn't happen. That's a really good thing to remember.
And a way to look at that too. So let me give you a good example, real life example of this.
Okay.
You're going to build a pool, and the board president comes over and says, wow, a pool's great. You don't need architectural control. You don't need to go through the architectural control committee. Just move forward with your pool. You're good to go. And you take that. You say, well, it's the board president. I can take their word at it. You build the pool. And then as soon as it's done, you get a violation notice saying, hey, this never went through the architectural control committee. And you're now going to say, well, Billy Bob told me that I could do it. Well, if it's not in writing, it really didn't happen. So if that does happen, if you get some sort of confirmation from the board or a board president or whomever, put it in writing. And simply that would be, dear board, I just spoke with the board president. He gave me authorization to install the pool, saying that I did not have to go through the architectural control committee. I'm relying upon this representation. If this is not accurate, respond in writing.
Yes, I love this so much because you are more memorializing it.
Yes.
You are, even if you had a conversation between two people, you can go back, send the email, and say, if I have this incorrect,
respond in writing. And that's important too. That's a small little pro tip there. But if this is inaccurate, respond in writing.
Yes.
Because what could happen is they could respond vis-a-vis a phone call.
Yeah.
And now you don't have that in writing.
Right.
So just sort of, again, everything in writing.
Yeah.
And that's so important. So that was T, in track. And the R, record and organize your evidence. This is important too. This kind of goes to the T, but this is where you are sort of generating your timeline, your chronology, you're saving the letters, you're saving the photos. And at the end of the day, you kind of assume that this is going towards possible mediation, litigation of some sort.
Yeah.
You just create a file. Just be organized, even from the outset.
Yeah.
Because what happens very quickly, there's a lot of documents that come in, especially if things go south.
Yeah.
And you do not want to lose or misplace a key piece of evidence.
Yeah.
Right. And so the more organized you are, it's just going to behoove you in the long term. Hopefully, you're going to be able to present a case to the board. The board's reasonable and you're able to resolve it. But if you have to go to a lawyer and you come in with a complete file, an organized file, not only that is that going to put you in better footing when that advocate is going to go up against the bad HOA, but it's also going to save you the attorney time, which will save you money.
100%. I was going to say that going up when you're all the way through and you're think long term.
Yeah.
If you're going to get an attorney, how are you going to hand this over to them?
Right.
Do you want it organized? Do you want it concise? Do you want a timeline there? Because that will really help out. We have a whole episode on how to prepare for consultations. If you are doing this ahead of time, there's no preparation. You have everything ready to go. And the knowledge transfer will be so much easier.
Correct. And again, listen, a good lawyer can go in and go through 20 banker boxes of information, but it just takes more time, effort, and you're going to save so much economically.
Yeah.
Just going in with a clean file. And if you've documented everything as well, that's just going to bolster your case.
Yeah.
Because it's easy to forget key events.
Yeah. I mean, I think we can say, emails, letters, violations, any sort of noticing that you get. Pictures. Let's take it back to you've got a condo and there's a problem with the roof.
Right.
Take pictures, and keep those organized. What if there's a political sign or whatever the case may be on your neighbor's lawn? There's one on yours. You get a notice. You're not sure if they have a notice. Take the picture. Then you can start digging in a little bit more. But you are putting together a really strong file that hopefully you don't need.
Right.
But you're prepared.
No, you're prepared. And, also water damage, I think that's very important. If a contractor comes in, has to open up a wall, photograph that, video it, it's very powerful evidence.
Yeah.
So. All right, that's R.
Yeah.
Let's move to I. So I is invest in knowledge.
Yes.
And this one is relatively broad, but really what it gets to is understand your CC&Rs, understand your governing documents, understand if there's applicable statutes that apply to your scenario. It's worth investing in looking into these things.
Yeah. So this is a pretty broad one. Knowing what I know now, which I didn't know before we started this whole thing, is so often the disputes arise from an HOA will tell you one thing, but the CC&Rs say another.
And that happens time and time again.
Yeah.
And it's easy. Remember, from a board's perspective, they speak out of turn, or it's inconsistent with the governing documents. They're kind of banking on the fact that you're not going to go verify.
Do you think it's that, or do you think it's also that they are ignorant, or they just don't know, or they don't care?
It depends on the personality type. Right. And we've gone into that before. You have a tyrant board member.
Yeah.
They're going to say, well, the CC&Rs don't require us to do that.
Yeah.
That's what a tyrant would say. And even if they know that they actually do.
Yeah.
And they're banking on the fact that the homeowner won't go and verify.
Yeah.
Versus the fool, which is another sort of prototypical bad board member, may just not know. Either way, you verify though.
Yeah.
Check it. And you should have access to these documents.
And I've said it multiple times that I always had the perception of the CC&Rs tell the homeowner what they can and can't do.
Right.
But it also lays it very clear what the board can and can't do.
Well, it puts parameters around the board. It is a set of requirements and enforcement. It's an enforcement mechanism, right? It's saying, board, you have to, let's say, maintain the common area.
Yeah.
And this is what the common area is defined as. And when they don't do that, you have the right to enforce those documents.
Yeah.
Right. And so it becomes so powerful. But in order to even get there, you have to read the documents. You have to spend the time, and that's where the investment comes in. But again, that turns on knowledge, and now you're operating in an elevated state.
Yep.
So I is very important.
And then it should also be noted too that you should get to know if you have your CC&Rs, you've got your bylaws, you've got the rules, but then you have local, state, and federal laws.
Right.
And we've seen it multiple times, California being an example of a law change in California, for instance, for ADUs. They've made it a lot easier for drought-tolerant plants and for solar, but those are in complete conflict with the CC&Rs.
Yes.
And a board may say, our CC&Rs say you can't do X, Y, and Z, but there is a hierarchy of the law. If those CC&Rs haven't been updated to support that law, they might not be valid. So doing your homework on going a little bit higher up the hierarchy could really behoove you.
More of an investment. And by the way, I love this, Marty. You prepared this. I don't know if anyone can see this, but essentially we're going to be posting this, and we did a beautiful job. Marty did a beautiful job sort of identifying the hierarchy on the left, or actually right side of this thing, where it goes federal, state, local, CC&Rs, bylaws, rules. And that's just a good guiding North Star when you're looking at these the interplay of all these different rules and regulations and statutes. Okay. So invest in knowledge. K, I really like, and that's keep it precise.
Yeah. And this goes back to the requests that, okay, you're going to stay calm. You're tracking your evidence. You've recorded you've invested in knowledge. You have everything there. This goes back to the requests.
Right.
Right. Like, how do you make the requests and keep it precise is one of those.
Well, I think precision's always important. And, it's one thing to say, hey, board, you guys are in violation of the CC&Rs.
Yes.
Or you guys are violating the governing documents.
Yep.
Or you guys are violating my rights. Right. But if you can say, board, you're violating provision 3.71, which is on page 9.
Yep.
That's a very powerful statement.
Well, we've said it so often that elevating your vocabulary puts the board on notice.
Right.
It's instead of being emotional, just saying, you can't do that. But if you just say clinically and refer to your CC&R X, Y, and Z.
And exactly where it is.
Yeah.
And what's interesting there too is, let's say this gets in front of the opposition. The board typically has an attorney.
Yeah.
And the attorney sees your letter and says, oh, wait, what is provision 3.17 or whatever it is?
Yeah.
That attorney will likely look that up.
Yeah.
Right. So you're actually helping them. You're making your case a little bit more user-friendly for all those involved.
Yeah.
Versus this is just a violation of the governing documents. Okay, well, at least you're talking about governing documents, but let's elevate even further.
Yeah.
Let's pinpoint.
Yeah.
And that becomes a very powerful tool.
Yeah.
So I really like keep it precise. And then E, I think, is very appropriate. Escalate only if necessary.
Yeah, I think so many homeowners have the disposition, especially in their home, on you want to escalate. You know what I mean? You have that predisposition of I'm angry. This is my home. So there's
scorched earth is your immediate reaction, right? And listen, I understand the sentiment, and there's certain situations where the HOA is so bad you can read the writing on the wall.
Yeah.
You know that if you lay out everything, maybe you've already done that the board's just going to stonewall you, shut you down, and escalation is a foregone conclusion.
Yeah.
But there are other situations where you're going to want to try to work with the board initially before lawyering up.
Yeah.
And if you can do that, that tends to be a huge win. It's a win for you economically. I think it's a very efficient way to resolve a dispute.
Yeah.
Now, a way to kind of thread the needle on that, of course, is you could always use a lawyer in a consultation base, right? That's a little bit more of a strategic way to leverage a lawyer's insight.
Yeah.
So meaning you could put a case together in theory, sit down with a lawyer, hire the lawyer for an hour, and have that lawyer review and give you pro tips or pointers.
Yeah.
Without going full advocate, we're suing, we're going after the jugular.
Yeah.
So there is a way to balance it as well.
Sure. And we put some bullet points in here. Now this only applies to California. Obviously, you're a California-based attorney. Request IDR under the Davis-Sterling Act when appropriate. You want to give the people a little bit of a
we love
background
IDR
on that?
here.
Yeah.
So IDR, what it is under Davis-Sterling is you as a homeowner have the right to demand informal dispute resolution with the board. And typically what that means is that there's some sort of dispute, you want to sit down with the board, and you want to have a moment where you can exchange information.
Yeah.
And if you have a reasonable board and you're able to sit down, exchange, have a conversation, that tends to be a really good thing. Because often what I find is sometimes boards just don't know what's going on.
Mm.
There's a breakdown in communication. IDR under Davis-Sterling is a way to sort of force the issue.
Yeah.
And to initiate that, you send an email to the board or to the management company or both saying, I formally request informal dispute resolution under Davis Sterling. Here's my dispute. I would love to meet. Please provide some days and times. Typically, it takes place at a clubhouse. Sometimes it's over Zoom.
Yeah.
But again, information gathering, exchanging, and really you're trying to drive that towards some sort of resolution. Now, that's California. Other states may have something similar.
Yeah.
I just don't know.
Yeah.
So, you're going to have to talk to an attorney in your state to see if it's applicable or not, or do your own research.
Yeah.
But at least in California, it's powerful, but that presupposes the board is somewhat reasonable.
Yeah.
Because otherwise, IDR can be a complete disaster.
Yeah.
We've had clients with really strong cases go to an IDR and just get shut down. And it was just hyper non-productive, a lot of visceral, a lot of anger, a lot of emotion.
Yeah.
And sort of going back, if you go into IDR in good faith and you think that the board's going to be very reasonable and they're not, this goes back to the first one, stay calm. Because if you start yelling, if you start engaging them at that time, that could also be used against you. So just shut it down. Just say, hey, this is not effective. I thought this would be more productive. I'm going to terminate the IDR. You have the right to do that. You don't have to subject yourself to further harassment or nonsense.
But it also goes back to you're showing the consistent pattern that you are the reasonable one throughout the entire process, which will absolutely bode well for you.
Well, also too, if you do have a very unreasonable board and they're not going to accept IDR, you could still request it in good faith.
Yeah.
And then if they shut that down, I think it's very telling of what type of board you're working with. Yeah. And that will likely come up maybe at a mediation or maybe in some sort of adjudication down the road.
Yeah, that you tried it and they totally stonewalled you.
Yeah.
Again, all of this is a pattern going back to the very beginning. If you're mindful of this, all of this stuff in the beginning, you're going to put yourself in a lot better footing.
Yeah. And I guess at the end of the day, again, bad HOAs don't play their game. Be reasonable, be calculated, and the paper trail, your conduct should always position you as the reasonable party.
Yeah.
Right?
I want to do a shameless plug too, because we didn't mention it here, but it's kind of it's within the invest in knowledge and record and organize your evidence is request the documents. Yeah. And we just did an episode on that one. Our last episode is all about what you can request, what you can't request, what happens if they don't comply. There's, at least in California, there's some there's consequences if they don't comply. But you can absolutely you're entitled to a lot, and I think that's a great episode. We just finished it for those who want to use that and supplement that as well. But anyway, getting back to E, I love this one so much that you've identified before. If an association brings an attorney, you should probably have one too.
Yep, I agree with that. I mean, listen, at the end of the day, that attorney isn't necessarily your friend.
Yeah.
Right. They've been retained by the board. If the attorney shows up, you want to have equal footing.
Yeah.
And at the end of the day, unless you're an attorney, there's likely going to be some sort of unequalness or an imbalance between the two parties.
And that attorney knows that and is going to try to put you in put themselves or their party in a position of power.
Well, they want to outmaneuver you.
Yeah.
And they're going to do what they can to do that. Right.
Yeah.
That's not atypical. That wouldn't be a surprise. So it's just something to be mindful of. And typically in IDR, the goal is really for the board to meet, you to meet, no lawyers involved.
Yeah.
Now, sometimes they'll bring in a lawyer. So just be mindful of that. And if that happens and there's a lawyer on the other side, you're free to shut down an IDR.
Yeah.
Again, it's the reasonableness. Now, if the lawyer steps in and shows up and is very reasonable, seems pragmatic, right? And just wants to get their head around it, you got to gauge it. It's case by case, but always feel free to shut down an IDR if you think that it's not going in the right direction.
Is it fair to say, because my general assumption when I hear that is always assume they're trying to outmaneuver you?
Yeah, always assume the worst. But it's not. That's
points for life.
Yeah, it is in some ways. Yeah, but I mean, if you go in overly optimistic and maybe overly naive,
I think that's the point. You don't want to go into this naive,
right?
I think if you understand that they're likely trying to outmaneuver you, you can be, just be aware.
I think you're more strategic.
Yeah,
and you just keep a higher guard.
Yeah.
Right. Don't let your guard down.
Yeah.
And so I think at the end of the day, strike method really becomes very strong footing and a good way to think about any dispute.
Yeah.
Right. And so I'm very excited about it.
We got to finish the last one though, which is if the board ignores you, stonewalls you, or continues to give you the runaround, that's probably time to consult with an attorney and just get that consultation.
Yeah. It's how do you break a log jam?
Yeah.
And
You've tried everything else. Those are maybe some triggers that maybe it's time.
Well, it's a lever to pull.
Yeah.
Right. So if you're sending communications, if you're like, hey, I'd like to go to IDR and they're not responding to that, or you've presented your case and they said that there's nothing in this case and we don't acknowledge provision 3.17. We don't agree with it.
Yeah.
Or there's just maneuvering that you're not getting any traction.
Yeah.
I would go advocacy route.
But what I love about this whole thing is that if you're following this, if you get to the point where you bring on an attorney, you're in such good shape. You've put yourself on good footing. You've put this whole timeline of events together. You're just in so much better shape than had you not followed the method all the way through.
As I see it, you're not running a dispute blindly.
Yeah.
Because what I see quite frequently is homeowners are kind of first and foremost blindsided by a bad HOA, right?
Mm-hmm.
And I'll give it to them, or I'll explain it this way. So you have a beautiful condo and a pipe bursts, not your pipe, and it floods your condo. So you're dealing with that, right? That's bad in and of itself.
Yeah.
And so now you're emotional, you're maybe living outside of the condo. You go to the HOA and say, hey, I'm seeking reimbursement. We want to, by the way, often your insurance has already denied the claim. So you're looking to be made whole again. But the HOA is shutting you down, not working with you, not being responsive. So you're very emotionally charged. There's a lot going on. Your entire life has been disrupted. You're trying to figure out economically what you're doing. And so you don't necessarily have an immediate framework or way of thinking about it. You're very reactionary. You're upset. So that's where you get that 3 a.m. email to the board because you're furious. But if you can at least stabilize and kind of have this North Star of the strike method to think about as you move forward, it's to some extent guardrails, but it's more than guardrails. I think it's sort of a way to position yourself in a very strong way against a bad HOA without sort of going off the deep end, right?
Yeah.
Because your natural inclination, there's so much going on, it's very easy to sort of torpedo even a good case.
Yeah.
And by thinking of strike and the approach, it's just going to position you in a very strong footing against, really bad set of circumstances.
Yeah. Well, as you alluded to, we turn this into a sheet, and it's going to be available on our subreddit.
Yeah, subreddit. I love the traction we're getting there. And again, and we talked about this several times, the subreddit was really to empower, give the people resources, give them tools.
Yep.
And, obviously the podcast is a tool, right?
Yeah.
Educational tool. The book is an educational tool. And we're going to keep rolling out content similar to this as well to continue the empowerment. But again, we consolidated it on that subreddit page. And I think that's,
Yeah. So if you're interested in this, it's a fun little sheet. It basically, we just went through it, almost line by line. If you want to have this, go to the subreddit. We're going to post it there. It's got all sorts of examples and things that, and hopefully you will find it interesting. And we want to hear. I would love. There's nothing more enjoyable than when the attorneys or client services or whoever says, "Oh, we heard the podcast. We came here because of the podcast. We did X, Y, and Z, and this was successful." It's so rewarding. And so I would love to hear once we post this and make this available. Did it work?
Yeah.
What did you use? What was effective? And share it with other homeowners, because I think what makes the subreddit so amazing is people can validate these concepts. They can say this worked, or I made a variation of this.
Yeah, the modification becomes interesting because, we have a subreddit, we're rolling this out, we stand by the strike method. I think it's fantastic. But someone says, you know what? Here's a pro tip on this.
Yes.
And now the community is empowering itself. And that's what we're looking to do with this subreddit.
Yeah, we have lots of plans for really cool, really hopefully helpful tools.
Really powerful tools too.
Yeah, there's lots of things that we have planned out. 26 is going to be a heck of a year. I hope people are excited about it, because we're super excited, because this is like scratching of the surface.
This will be the tip of the iceberg of many more things.
Oh my gosh,
come.
the amount of stuff that we have just in tools.
Yeah.
Tools to help homeowners. I think it will be extremely powerful, and I'm excited to release it. So check out the subreddit, Strike Method, fun sheet. Yeah, I'm excited for people. Like I said, I'm excited for people to comment on it and see what was successful.
Yeah. So. Well, thank you, Marty. Another great episode.
Yeah, it's great.
And thank you guys for watching, and leave the comments. And again, go to the subreddit though and join the community, join the movement. And thank you so much for watching.